How could you possibly love white people so much?
It's easy. Have you ever looked at them? White man just a joy to be around. They smell like lemon juice and pledge furniture cleaner. And look at them. They gave us discipline, jobs, put structure in our lives, took us out the jungle. And what we do to show our appreciation? We march up and down the street. We vote. Carry on. Ingrates.
Clarence Thomas has finally lost it. Hi, I'm Reese Waters, and I'm troubled. Justice Uncle Clarence Thomas actually fixed his face to criticize the landmark Brown v. Board of Education decision for enabling the court to limit racist redistricting. The Supreme Court's 6-3 ruling in Alexander v. South Carolina NAACP has severely undermined efforts to combat racial gerrymandering. Justice Samuel Alito's opinion for the conservative majority dismantles precedents that protected against racist redistricting, giving state legislatures broad new powers to segregate districts by race. However, Clarence Thomas found Alito's opinion insufficient. I believe he said not anti-black enough. In his solo concurrence, Thomas called for overturning all precedents restricting gerrymandering, including those establishing one person, one vote. He argued that the Supreme Court has no constitutional authority to redraw maps and blamed Brown v. Board of Education for the court's overreach in redistricting. So if you're scoring at home, this man has gone after affirmative action, he's gone after voting rights, and now he's going after segregation, or rather, the thing that kept us segregated. Yes, separate but equal. That's the thing that he finds a problem with. I wonder what is next. Jim Crow, freeing the slaves? Well, really, Lincoln was wrong. Lincoln was wrong with the Emancipation Proclamation because all precedents are for the preservation of slavery. So if we're going by precedent, then obviously he had no authority. He had no authority to do that. That's not to mention the fact that I have read that, and it's a couple of typos in that too. It's a couple of, because he missed a couple commas and he missed a couple periods, all his T's not crossed. It should have been thrown out. It should have been thrown out. I myself outlined Clarence Thomas's consistent anti-blackness here. But I clearly should have made that a series because the man won't be finished until he's the only one left. Yes, we all know a Clarence Thomas, the kind of person when you travel on vacation and you see another brown face and you give the nod and he just stares at you crazy. Don't even give you the nod back. All you get is the energy of somebody mad that he's no longer the only one. You know, these are my white people energy. That is what we have on the Supreme Court. Now, Brown, the 1954 decision declaring racial segregation in public schools unconstitutional, is actually celebrating its 70th anniversary. So is this some timely contrarianism? Did he just find a way to, you know what, I'm just going to rain on everybody parade because too many black people too happy. And you know, nothing gets my robe in a bunch than when I see black people happy celebrating something. Actually, I will let him off the hook for this. Thomas has actually long criticized Brown v. Board of Education. Yeah, he got a history of hating on the thing that took us out of segregation. Imagine that. Claiming it erred by focusing on the stigma of segregation rather than the constitutional harm of denying black children access to integrated education. He has opposed the court's integration efforts, arguing they were based on the false premise of black inferiority. What? So the argument was based on blacks' inferiority and not the inferiority of the conditions that black people were faced with? I'm pretty sure that was the basis for dismantling separate but equal, because wasn't no equal. wasn't no equal, there was no intention of being equal, and therefore there was no justification for separate but equal. But all of a sudden it's based on black inferiority. Everything that you have a problem with that has helped us is based on black inferiority, right? It was that was the justification for the voting rights thing, and that was justification for affirmative action, right? So I guess that will be your justification moving forward for the 13th Amendment, right? Well, it's based on black inferiority. I mean, really, because if blacks were equal, they would be able to free themselves. So ain't no reason for us to intervene and free them. And by the way, when that happens, I want to be the leader. Yeah, I keep them in line. Thomas's recent critique in the Alexander case reflects his frustration with the Supreme Court's role in addressing racial discrimination. Now, the case involved a South Carolina district that became competitive for Democrats. The Republican-controlled legislature reconfigured the district by moving thousands of black voters out and white voters in, solidifying the GOP advantage. A federal court found this map unconstitutional, but the Supreme Court reversed this decision, claiming that the legislature's intent was partisan and not racial. Oh, I get it, because it was partisan, but it wasn't racial. I get it. So it wasn't based on race. It was kind of just based on like culture. You know what I mean? Like they asked people, who Barry Manilow or Marvin Gaye? Barry Manilow? Okay, you in. Okay, what's our national pastime? Baseball? Okay, you in. How do you feel about the NBA? Well, they don't try hard before the fourth quarter. I prefer college basketball because they really give their all. They really out here playing for not just themselves and for the money. They are playing for the name on the shirt, not on the front of the shirt, not the name on the back of the shirt. Congratulations. Welcome to District 5. Alito's opinion raised the bar for approving racial gerrymandering, requiring plaintiffs to show that lawmakers targeted them based on race, not political assumptions. This effectively allows legislatures to diminish the voting power of black communities by redistributing them into districts where their votes are less impactful. So let's see, let me get this straight. It was based on political assumptions, but not race. Okay, it was based on political assumptions, but not race. So it's okay to make it based on political assumptions. Now, what were the political assumptions based on? Go ahead. I'll wait. What were the political assumptions based on, if not race? It wasn't based on race. It was based on partisanship. It was based on what we thought their politics would be. So what was the basis for what you thought their politics would be, huh? How new were their shoes? Whether or not they had rims? Exactly what was the political assumption based on? But that wasn't enough shuffling for Uncle Clarence. Thomas had to go further, rejecting the court's authority to invalidate any redistricting plans. He argued that the court's power to redraw maps emerged only in the 1950s due to frustration with resistance to Brown v. Board of Education. Thomas believes this power is inconsistent with the historical judicial authority and the framers' intent. Okay, so we are trying to recapture the intent of the people that own slaves. Is that what we're doing? Is that what we're doing in 2024? We want to recapture the intention of people. With regards to race, we want to recapture the intention of people that own slaves. I got it. I think I got it. Thomas linked the roots of the court's redistricting authority to Brown and argued that both are abuses of judicial power. He criticized the court's past decisions to outlaw malapportionment and limit racial gerrymandering, viewing them as overreaches. Thomas contended that the 14th and 15th Amendments address only ballot access, not the practical impact of gerrymandering and malapportionment on voting power. So you would take from that you at least want to ensure ballot access, but you didn't do that because you went after voting rights previously. Under Thomas's view, extreme racial gerrymandering, like Virginia's post-Brown tactics to suppress black political power, would be constitutional. He argued that courts should not intervene in redistricting which should be left to political branches, even if it means that racial minorities are effectively disenfranchised. And I would change that to especially if it means that racial minorities are disenfranchised. Thomas's stance raises questions about historical accuracy, as the post-Civil War amendments aim to ensure full equality for Black Americans, potentially prohibiting racial gerrymandering. His narrow interpretation of these amendments suggests a preference for allowing state legislatures to use race in discriminatory ways, counter to the abolitionist goals and the principles upheld in Brown, and a preference to remain the only one standing in white spaces. Let's not forget that. It must kill him to see Ketanji Brown Jackson. It really must kill him. Every time she comes around, he got to react like the dude in that Key and Peele sketch that was the only dude in the improv troupe. Now I know how we can get rid of Clarence Thomas. We got to pack the court, but pack it with Black people. You just keep a bunch of Black people around, Black people protesting, Black people AIDS, Black people just Black people all around. That's how you get him out of there. That is no doubt how you get him out of there. Now, I would like to end with this. Brown v. Board of Education is something that is extremely important to me because I am actually a descendant. I'm a great-grandfather of Levi Pearson, who filed a case in Clarendon County, South Carolina. That was one of the cases that Thurgood Marshall traveled around the country and looked at before he chose Brown v. Board of Education. So I've always felt close to Brown v. Board of Education. I've heard all the stories of what it was like for my grandfather and also for my mother to go to school, my aunts and uncles to go to school. I've heard those stories. I've heard about the conditions. I've heard about the abuses. And for all of the work and all the effort that they put in, one of the things that I find to be a North Star for me and a shining light for me is trying to take step forwards and do right by the sacrifices that they have made. And I'll be damned if their hard work and their efforts and their sacrifice is going to be blighted by a for sale, off-brand justice trying to preserve his spot shining shoes on a private jet for right-wing donors headed on a vacation he can't afford on his own while his wife stirs an insurrection from the economy bathroom. I won't have it. And that is why I'm troubled.